Good afternoon, everyone, and welcome to our presentation on UK student visas. The training is conducted by LS Legal Solicitors. My name is Elena. I am a trainee solicitor. LS Legal Solicitors, by way of introduction, is a multi-serviced law firm. We are based in London, and we are a diverse and fast-growing law firm, which is offering a wide range of legal, accounting, and concierge services for our clients around the world. We have more than 15 years of experience, and we are accredited by the Solicitors Regulation Authority. We have three companies or ancillaries that are providing services. The LS Legal are providing legal services which include immigration, corporate and commercial law, family law, and employment law advice. Accounting services are provided for companies, and companies are supported in their bookkeeping and accounting, in their company formation. We can also help with HMRC registration and opening of bank accounts. Family office is focused on providing services to individuals and businesses in lifestyle management, business concierge services, education, certification, and legalization of documents. We can also help with powers of attorney as well. Today, we are focusing on student visas, a very hot topic, especially in the autumn. The UK is still attracting a lot of talent around the world, and therefore we thought that this training will help you with supporting individuals around the world in their student visa application. There are three things that anyone should consider when applying and helping. First is suitability. Suitability means that an applicant should not be on immigration bail and that an applicant should not be in breach of immigration rules. The eligibility requirement means everything that we will be talking down the line. It means that the applicant should have a certificate of acceptance of studies. The applicant should have appropriate finances to support themselves throughout their stay. The applicant should have passed the English test as well as provided tuberculosis test certificate, and the applicant should be a genuine student. The validity requirement basically means that the applicant should have a certificate of acceptance of studies which was issued no more than 6 months before the date of application. It also means that the appropriate immigration health surcharge was paid, as well as the visa fees. For a student visa, it also means that someone should be at least 16 at the date of their application, and they also should have provided their passport and biometrics, which is fingerprints and their picture at a TLS or VFS service center. Now, there is a difference between an application being not valid and refused. The application can be rejected as invalid when the validity requirements are not met. The difference is that if an application is refused, or rather the applicant is not granted a 3C section leave, meaning that as soon as the application is invalid, the applicant, if they are in the UK, they are illegally in the UK, or rather they are illegally if at the point when they applied, after they have applied, for example, their visa has run out. And then if their application is invalid at that point of time, basically they have no valid leave to stay in the UK. So in that sense, if you think about it, it is much more, it's much worse for someone's application to be invalid. So please be careful that all the visa fees and all applicable validity requirements are met. The application forms, we have to be careful about the application forms and have to take instructions from the client. Very often you would see that the application forms are filled out based on generality and not on specific circumstances of the client. If a mistake is made, it is interpreted by officials as an attempt to mislead or deceive, and it can lead to horrendous consequences for clients. Two effects. So the application concerned will always be refused no matter what. And if the application was for entry clearance, future applications for entry clearance will automatically be refused for a period of 10 years if the applicant has used deception. The applications from the UK, you can switch in country unless a person has a visitor visa, a short-term student visa, a parent of a child student visa, permission as a seasonal worker, as a domestic worker in a private household, or outside of the immigration rules. The certificate of acceptance of studies is obviously the document that is issued by an appropriate sponsor. This document must not be withdrawn and should not have been used before. The document must state whether the course was paid and the cost of any accommodation provided by the sponsor. So, for example, we could be talking about someone who is living in an accommodation or in a boarding school. It should also state that the English language test was met or was met in some other way for someone who is younger, probably. And it should also meet the following requirements. The course requirement, so you have to be aware that not everything can be sponsored. So usually it's full-time level 3 or above, or part-time courses at level 7 or above. There is a regulated qualifications framework that you should be referring to. It should be approved qualification. The level of qualification should be met as well. Like I said before, level 3 or above usually, or most often. And the place of study requirement. Usually the student will have to study on the premises of the sponsor or their parent or their partner institution. Genuine student requirements. Very often we are asked about the interview process as well as what is a genuine student requirement, and this is very often overlooked for the very reason that a lot of helpers and assistants or even lawyers get bogged down into details, and then this is easily overlooked. Genuine student requirement means that a person has to be age 16 or over. Both the application and the interview will be assessed, which means that it's not just the application or the documents that are important. The Home Office official has to be satisfied on the balance of probabilities, which is a civil law, and it's much less onerous than, say, beyond reasonable doubt. The Home Office must not refuse on grounds without interviewing unless the application has been refused previously on genuine student grounds. There have been no changes to the material circumstances or no new evidence has been provided. Or there has been a significant number of identical applications and the Home Office caseworker or staff member has interviewed a sample of these applicants and is satisfied that they are not genuine. And the facts of the case mean that the applicant would not be able to refute the allegation of lacking credibility. This basically means that if, for example, someone is an agency submitting identical or similar applications in their essence, and some of the applicants have been interviewed and the Home Office came to the conclusion that they're not credible, this might seriously prejudice all the remaining applicants. The English language ability of an applicant can be used as a relevant factor in assessing credibility as well. There are certain factors that the Home Office will take into account when assessing whether an applicant is a genuine student. It's firstly immigration history, any previous applications, any previous refusals. The personal and financial circumstances, so for example, the credible source of funds, how the applicant was able to acquire the necessary funds, the distance between the place of study and the proposed accommodation in the UK, the average monthly expenditure. The educational history and post-study plans as well. So there has to be sufficient commitment to the course. There has to be academic progression, there has to be credibility, there has to be knowledge of the research of the institution. If the applicant also has to say that they intend to comply with all requirements of their visa as well. If the applicant is, or if the applicant's decision to choose the university was because their friends or their family or their agent told them that this will be good for them, that's fine. You shouldn't lie. However, you still have to make sure that you can explain why this particular institution is an institution of your choice. The qualifications, course provider, and agents, that's very important as well. So if an institution is under investigation or has been identified by the Home Office as an institution of concern in relation to their compliance with their own obligations, then this can be an issue as well. Some other small tips on how to conduct yourself on the interview. You have to make research of the school. So if you boil everything down, you have to know why you want to study there, and you also have to be credible, and your story has to be credible, which is very easy in a way that you just have to know where you're going to live, and what are your study arrangements, and what is it that you're studying, as well as how you're going to get to your university, and what are your accommodation arrangements. You have to treat the interview as if it is a work interview. It's quite serious. So you have to dress properly. You have to be aware of the microphone. You have to be aware of your body language. You also have to sound confident. You have to know why you want to study there, and you have to be very honest about it. And you have to try to use plain English and be clear. Again, don't forget that your English language ability could also be assessed at this point. Now, going to the financial requirement, I have to start from actually saying that this is a very specific requirement. It really has to be calculated on a case-by-case basis. It also depends on the certificate of acceptance of studies. Usually you have to have sufficient funds to pay outstanding course fees for the first academic year, and you have to demonstrate funds to cover your living costs up to 9 months. It really depends on where you're going to study. So, for example, if you're studying in London and you have paid some of your fees, then you have to show sufficient funds to pay any outstanding course fees, the ones that are as stated in the Certificate of Acceptance of Studies, plus £1,334 for each month of the course up to a maximum of 9 months. Please be very careful. This is a very, very common mistake. You have to show that funds are held, of funds in the required level and of the required level are held for a consecutive 28-day period, where 28-day period must end no more than 31 days before the application date. This is a very common mistake. The applicant will automatically meet the financial requirement if they are applying for permission to stay in the UK and they have been in the UK for at least 12 months with a valid visa before their date of application. If they're applying as a student union sabbatical officer or in some other limited circumstances. English requirement. English language ability is assessed in reading, writing, speaking, and listening of at least B2 if it's UK's bachelor degree or above, or level B1, everything else. So it's pre-sessional course or anything below UK's bachelor degree. The Certificate of Acceptance of Studies will usually say as well what was the method of assessment. And we would suggest you to check the providers. The Gov.uk website has a list of providers outside of the UK as well as inside of the UK, and very often they are changing. And so please make sure to check as often as possible. There are some other requirements to consider. So firstly, there has to be an academic progress. An applicant who has had a permission of student route and is applying again has to show academic progress, which means that from previous courses they are going higher. So unless they are receiving examination or they are continuing on their PhD. The maximum period of study as well is important. So it usually is below degree level, it's 2 years. At degree level, no more than 5 years from the age of 18, unless the course of study is, broadly speaking, architecture, medicine, dentistry, veterinary medicine, and science, music, add to music college or law. You have to be really careful about the postgraduate, doctorate, or dentist as well. There are some certain requirements in relation to that. If the applicant is aged 16 or 17, they must have written permission from both parents or one parent if that parent has sole legal responsibility, or from the applicant's legal guardian if that is applicable in your case. Other options that we can also discuss is short-term student. The short-term student is for someone who wants to start a course in English language. The course provider has to be an accredited institution, and they have to show the applicant has to show that he has been accepted onto an English language course that lasts no longer than 11 months. Please bear in mind that this is very different to student in a way that this applicant has to show that they have something to return to, if we say, and if we put it quite broadly. So the person must not intend to stay in the UK beyond their visa, must be able to maintain and accommodate themselves adequately and have enough funds. They must be age 16 or over. They also have to show that they do not intend to make UK their main home, which is a very broad requirement, and usually it's very specific documents that have to address this very broad requirement. Child student visa is for the applicant who is aged 4 to 17. So they have very similar requirements to the student visa. And again, it really depends on individual circumstances, the course and the certificate of acceptance of studies. There is no English language requirement. However, it depends on the school and the school's requirements for accepting a child student. Parental consent is as well required, and a child student can also do a pre-sessional course to prepare them for the main course of study. So, for example, they will study some skills or knowledge that is necessary to adjust to studying in the UK. A child student cannot take an English language course if they are under 16 years of age, and a child student cannot do a foundation course. Usually a foundation course is something that is at the level of 3 or 4 of RQF. We have discussed what other options we had, and now we can discuss what to do after someone has graduated. The visa, which has been recently introduced, is a post-study work visa, graduate route. This post-study work visa, most importantly, it does not lead to settlement. What it means is that usually in, say, for example, work visa category, which is now called, work visa category. Let's say, speak it broadly, it was tier 2 general, now it's skilled worker visa. You can settle after 5 years of being in the UK continuously, provided, of course, you meet some other requirements that are applicable at the time of application. But the post-study work visa, as well as the student visa, they do not lead to settlement. This means that usually if someone graduates and they are given the post-study work visa after 2 years, they have to switch. They have to switch to skilled worker visa, which is the work visa, or they have to think of some other category or switch to some other category. So this person, or rather the applicant for post-study work visa, they do not have to have a sponsor. They can stay in the UK, they can create their own company or start their own company. They can become employed, self-employed, or continue studying and living in the UK. Very importantly, you cannot add people onto a post-study work visa unless they're already into the UK, your dependents, your family. The visa costs £700, and the immigration health surcharge as well has to be paid of £624 for each year. So it will be 624 multiplied by 2. Usually it's post-study work visas for 2 years, with small exceptions. The requirements are that the applicant has successfully completed the course. They have completed, and the sponsor has notified the Home Office that by the date of application, the applicant has successfully completed. There is also a qualification requirement. Usually it's a bachelor's degree, postgraduate degree, or successfully completed a relevant qualification. For example, it could be LPC or the bar course. They should have studied in the UK as well. This means that if it's longer, if the course was for longer than 12 months, then it should be at least 12 months. If the course was shorter than 12 months, then it will be for the full duration of the course. Mindful of the coronavirus and the pandemic, we just have to say that there are certain certain things that we can consider, taking into account the travel restrictions and the fact that not all students would be willing to stay in the UK when whilst the lockdown. So there are certain reliefs and concessions in place. However, they have to be assessed on case-by-case basis. The person must apply before their student visa or Tier 4 general student visa expires. We look forward to hearing from you. If you have any questions, please drop us a line. We also have another recording and training on skilled worker visas, innovator, and other categories that a person might be looking after they have completed their studies in the UK. Thank you so very much for watching, and hopefully you will have a great day.